to the Pro Bono Happy Hour. I'm Rena Glazer. Welcome back. Summer is flying by. Quick reminder, that means that the PBI annual dinner is coming soon. The event will be in New York City on Thursday night, September 28th at the amazing Gotham Hall. More information can be found on the web at probonoinst.org or call Kelly Simon at 202-729-6691. We're grateful to all of our generous sponsors and supporters. Today, we're talking to Ted Howard from Wiley Rein. Ted spoke with us from his office a few blocks away from ours in Washington, D.C. We discussed his transition to serving as the firm's first full-time pro bono partner, his meaningful pro bono work on behalf of inmates and prison reform efforts, the firm's pro bono program, and more. We hope you enjoy the conversation. Ted Howard, welcome. Thank you so much for joining us today.
Thank you for having me.
Let's jump right in. Could you tell us about you? Share a little bit about yourself and your background?
Sure. I grew up in New York and Connecticut. My father practiced medicine in New York for more than 40 years, and so we were sort of a suburban family, but he, by either car or train, made his way into New York every day for many, many years on end. I went to Catholic parochial school, public high school, and then made my way out to the University of Notre Dame in South Bend, Indiana for college. I was a very avid high school athlete, not the most talented, but very passionate, and had some friends who were very, very successful football players who preceded me at my public high school and went to Notre Dame to play. And although I was not talented enough to join them on the football field, they did persuade me that it was a great school. So I made my way out there and really enjoyed my 4 years there, and went straight from there to Harvard Law School, where I graduated in the class of 1981. I spent my second summer after my second year of law school in the U.S. Attorney's Office here in Washington. And although I had a great experience, I was persuaded that being a prosecutor was not something that was in the cards for me, but I loved D.C. and couldn't imagine going anywhere else to work. So this is where I ended up, and I've been here ever since.
Fantastic. Let me step back for a minute because you mentioned that you went straight through from Notre Dame to Harvard Law School. Why did you decide to become a lawyer?
My dad, as I mentioned, practiced medicine. My mom was a registered nurse. They were very, very strong on education. I was the youngest of four children, and all of us were put through the rigors in terms of my folks' expectations with regard to how we approached our academic responsibilities. And although my older brother, who was the oldest, and my older of my two sisters, who was second in line, both sort of gravitated towards the hard sciences and either considered or did actually follow in my dad's footsteps into medicine. I was not the strongest math or science student, so if I was going to sort of maintain or live up to the expectations that my parents had sort of set in terms of us having professions, law seemed like the logical alternative for me. I was much stronger in the language arts than in the hard sciences, so it came a little bit easier, and as I got into it, actually sort of not just the academic aspect of it in law school, but the actual practical part of it in my summer jobs during law school, I found that it was very, very comfortable for me and, really sort of what I wanted to do.
I love hearing about your parents, and in my family that would be known as the "we can't stand the sight of blood" story. We became lawyers and not doctors. But
Right.
So you talked about having a DC experience and falling in love with the town. How did you get to Wiley Rein?
Well, I started at a small firm, I guess medium-sized by the early 80s standards, about 45 lawyers, called Hamel & Park, which basically got swallowed up in a what was really an acquisition, characterized as a merger with a large Chicago firm. I was at that firm for my first 14 years of practice. I finally left in 1994 to move on to the D.C. office of a New York firm where my principal insurance company client had a very strong relationship and was interested in having me and a couple of others from my prior firm go over to the D.C. office of this firm where they already had a very strong working relationship. So we did that for 5 years, and then in the fall of 2000, I got contacted one day by a colleague in the insurance practice over here at Wiley who indicated that they were looking for a couple of individual partners or a small group that might add some depth and trial experience to the existing insurance practice here. And having had friends and colleagues at Wiley Rein since it was basically came into existence in 1983 or 84, it was a good opportunity. I felt that we would be very compatible with the existing practice group over here, and frankly, getting out of the satellite office of a firm located elsewhere was very attractive as well. So we came over, our whole group, 5 of us, came over early in 2001.
How did you land in the insurance practice area to begin with? Is there a story there?
I guess there is. It's not all that interesting, but I was sort of a general purpose litigator at my first firm and did a wide variety of different kinds of things, all of which I found, stimulating, interesting, etc. But at about year 6, when I was still an associate, a lateral partner came into the firm and brought with him a fairly substantial volume of large insurance litigation matters, and he needed immediate support because he did not lateral in with any associates in tow. And so I got the call from the management to support this guy's practice if I was willing to do so, and sort of jumped into it. And before I knew it, I was beginning to become a specialist in complex insurance coverage matters.
And what did that mean? What were you doing? Tell us a little bit about your practice.
Right. Well, what it involved was representing large property casualty companies, which had in earlier years written liability policies for large corporate policyholders. And beginning in probably the late 70s, the law of toxic torts really sort of emerged, and all of a sudden these companies that had engaged for decades in practices that may have exposed their workers or others to asbestos, or they may have engaged in manufacturing practices that yielded pollutants that they basically dispersed into the environment. They might have been engaged in manufacturing certain kinds of products that were, thought to be safe and effective as used, but which had side effects, or if misused, caused, catastrophic types of injuries. And all of those types of liabilities for the companies resulted in their seeking coverage under their liability insurance policies, sometimes many years after the fact, of when they actually engaged in the conduct that gave rise to the liability. And so there were very complex contract interpretation issues as well as some public policy issues for the courts that had not dealt with these types of coverage concerns up until that time. And so we were basically engaged along with the often extremely capable, competent counsel for the policyholders in thrashing out before the courts how the policies should respond, if at all, to this sort of new wave of types of tort liability. And that's what the cases were about. They were massive in terms of the dollars at stake. They were often massive in terms of the numbers of parties involved. A company like, let's just take one for example, General Electric would have bought, extensive levels of what we call primary coverage, first dollar response to liability. And then on top of that, layers and layers of what it's called excess coverage in order to protect themselves in the event of a catastrophic loss. Now, when the policies were purchased, most likely it was thought that any such catastrophic loss would be a so-called big bang event, one isolated incident that caused, that resulted in an explosion or the failure of a dam or whatever, that would cause a significant number of people to lose life or limb, but all pretty much concentrated at one particular point in time so that the policies that were on the risk, quote unquote, at that time would be the ones that would respond, assuming that there was coverage at all. What was unique about the emerging tort liabilities that were coming into play in the late 70s through the 80s and into the 90s was that basic business activity over a period of years resulted in exposure of individuals to certain injury-causing agents or chemicals or products where the courts basically were confronted with the determination as to A, whether there was coverage at all, if so, B, which policies over the length of time that was implicated would respond and how and by and with at what level or how much. So that's what it was all about.
That is a fantastic tutorial, and it's actually giving me flashbacks to my prior life as a products liability defense lawyer. So I instead think we'll flash forward a little. Let's kind of zoom up to May 2014, when you had a big change. You became the firm's first full-time pro bono partner. Is there a story there? How did that come about?
That came about really as a function, I think, of the beginning of this firm's sort of generational change. There was certainly a strong and active pro bono culture in the firm, as of the time that I arrived in 2001 and carrying forward. But as our management started to change from not just particular individual to particular individual, but really sort of the first generation, the folks who broke off from Kirkland and Ellis to start Wiley Rein in 1983, had basically sort of run the firm, been in charge of management of the firm. And as that group of folks started to recede from leadership positions in the firm, and the second generation folks who had, started at the firm as first-year associates and come up through the ranks and become partners, and now we're in a position to sort of take leadership roles, started assuming more control. One of the consequences of that was the perception on the part of our management that we really needed to join with our peer, the firms that we consider to be peer firms in Washington in making more of a pronounced commitment to pro bono. And so when our managing partner, Peter Shields, mentioned just in sort of a casual offhand fashion, or maybe he's smarter than I think he is, but that, the management committee was sold on the idea of creating a position for a full-time pro bono partner, I just basically sort of blurted out, "Oh, I'll do that." I was, had been actively engaged in pro bono work. I was immersed in a prisoner's class action at that point in time that was taking up a lot of my time, and it just seemed like a sort of logical next step for me. If the firm was willing to commit to that level, that I should as well.
What do you think sparked that passion that you have for pro bono and access to justice?
I think it really, I don't want to sound like a broken record, but I do think that it really relates to how I was raised and who I was raised by. My parents were both, engaged in the healing arts, and they felt very passionately about being of service to people who needed their help and needed the things that they had to offer. They weren't vocal about, haranguing me or my siblings about giving back, quote unquote. But I think just sort of every day in terms of the way that they live their lives, they conveyed to us how important it was for us to take such gifts as we had and make sure that we put them to work in the service of other people.
So let's talk a little bit about your role. How do you spend your time?
Well, certainly the concept when I took the position was that I would continue to have an active practice. It was important to me to have that be part of the understanding, and I think it was important to the firm because of the matters that I was already involved in. But certainly I think the ideal concept was that I would spend about 50% of my time in active casework and about 50% of my time overseeing the administration of our firm's program and, engaging and enhancing our relations with legal service providers and, just making it easier for people to within the firm to get access to opportunities and to take advantage of those opportunities to the extent that they wanted to do so. Our pro bono committee, and we still have a very active and engaged pro bono committee, up until the time that the position was created that I filled, was chaired by one of our government contracts partners, an outstanding guy, a great lawyer, and very committed to pro bono work, but very, very busy in terms of his own practice. And so, the administrative aspects of the program were in need of care and feeding, and it was certainly thought that I would be in a better position to do that on a full-time basis than the guy who had been our pro bono committee chair. As it's turned out, I have found it difficult to disengage from the opportunity to be actively involved in the work. And I think it probably has more like 90% casework and 10% administration at this point.
That's interesting. So you may have already answered this, but is there anything that you wish you could be doing more of if you had more time?
Well, I certainly think that I don't kid myself that there isn't a trade-off, and a potentially important trade-off associated with the degree to which I am engaged actively in representation of clients in pro bono matters, because arguably more time devoted to the administrative aspects of running our program would only enhance the prospects and the opportunities and for others, and the likelihood that we might have a higher level of engagement than we have, which is certainly a good, strong level, but it could be better. And so, there's no such thing. The old saying is there's no such thing as a free lunch, and that's true. And in this instance, what that means is that by being engaged in matters large and small that require the lion's share of my time, and being responsive to court-imposed deadlines and client needs, etc., has probably had a less positive overall impact on our pro bono program than might have been envisioned when I took the position. Now, I am not taking any, heat for that from our management. Everyone, I think, understands and appreciates the commitment I've made in terms of, being actively involved in matters that make a difference in clients' lives and ideally shed some positive light on the firm. But nevertheless, if I had more time, it would certainly be devoted to the administrative side of the house.
What do you enjoy most about your work?
I think I enjoy the most the fact that I get up every morning and I come to work knowing that I'm going to be doing something that makes a significant difference for someone. The large insurance cases were intellectually stimulating and challenging and important to our clients, and I obviously never felt that I gave anything less than, full and complete effort. The kinds of cases that they were and the kinds of dollars at stake tended to result in resolutions that cause either significant amounts of money to be kept in-house at our clients because we defeated a claim for coverage, or large amounts of money changing hands between Company A, insurance company A, and manufacturing company B at the end of a lot of discovery and a lot of depositions and a lot of motions practice, and both companies coming to the conclusion at the end of the day that neither wanted to cast their fate to a jury. And so certainly over the period of time that I did that work, from about 1986 or 87 through about 6 months after I took the position as full-time pro bono partner and weaned myself from my remaining insurance responsibilities, there was a lot that I had done over and over again. I knew how to do it. I feel like I knew how to do it fairly well, but I didn't typically, I can't say 100%, but I didn't typically lose sleep over, what was going to be happening the next day and what impact that was going to have on the case. Pro bono work is very different in that every matter that you handle is of crucial significance to an individual or group of individuals and how their lives are going to be. And, that's energizing. It's also frightening sometimes, but it's always energizing. And, so that's what I really like about it.
You've been in this pro bono role for a little over 3 years now. What surprised you the most in that time?
I think what has surprised me is the extent to which I feel like my commitment to work has increased rather than either stayed the same or decreased. I think, conceptually, because the thought was that I would pretty much split my time between cases and administration, that my expectation was that at least on the administrative end of things, my hours might be a little more regular and that sort of thing.
Yep.
But, there's no question about the fact that my time commitment to work has increased pretty significantly from summer of 2014 to now.
If we had a third guest talking with us today, that would be the you from May 2014. What would you tell them? Do you have anything to say to the sort of looking back to the you from then?
Yeah, I don't know. I guess I would probably just say, be careful what you wish for.
Good luck.
But only in a joking way.
Yeah, of course. So I wanted to talk a little bit about your pro bono work, and you've already highlighted some of it. You've been really involved in a number of major prisoner rights and prison reform matters. It's a crowded market of potential pro bono opportunities. So first, what attracted you to these matters?
I think when I felt towards the latter end of my years as an associate, that I was really ready to sort of take on matters that I could handle on my own. I felt like I had sort of at least learned enough about the craft to not do any harm to someone's situation, even if I couldn't make it better. At that point, the DC Prisoners Legal Services Project, which was a small standalone organization, was sort of, I don't know if advertising is the right term, but they were certainly making it known in the legal community that they would welcome the assistance of whatever pro bono lawyers might be interested in taking matters with them. And I don't know if it necessarily occurred to me as significantly then as it has in subsequent time. But I think as, we're now sort of in a time period in society where there's a lot of recognition with regard to both the phenomenon and the impact of mass incarceration, particularly as it relates to the African American community. I don't know if I had thought it through to that point then, but in taking my first case from the Prisoners Project, which was a case involving 6 African American men who were all jailed at the DC jail and who basically had been subjected to vigilante justice, so to speak, by a sort of renegade band of guards who were pulling people out of their cells and administering physical beatings and spraying people in the face with mace and stuff like that. It just seemed to me then, and particularly as I thought more about it over time, that not having the temperament or necessarily the inclination to be a criminal defense lawyer, but nevertheless feeling very passionately about the plight of folks who are subject to the criminal justice system, and particularly African American men who are subject to the criminal justice system, that prisoners' conditions of confinement work that would make life at least a little bit more livable for people incarcerated, and that would allow them to come out of the system feeling a little less dehumanized, became important to me. And so I've continued to try to have at least some work that I'm doing at any given point in time involve those issues.
You also had an interesting prison case in Virginia. Could you tell us a little bit about that one?
Sure. That's a case that was initially brought to light by the Legal Aid Justice Center in Charlottesville. John Grisham gave a fairly substantial chunk of money to the LAJC to create an institutionalized persons project. At some point, I think probably as a result of a lot of the issues that he had chosen to write about in his novels. And so shortly after the publicity about this grant that he had given them, women from this facility called the Fluvanna Correctional Center for Women, which is one of the two women's prisons in the Virginia Department of Corrections system, and ironically, the prison to which folks that have serious medical issues are sent for supposedly superior care. The LAJC started getting flooded with letters from women complaining about the medical care at the facility, and they wanted very much to do something about it. They did not have a significant background in institutional reform type litigation, and so they brought the matter to the attention of the Washington Lawyers Committee for Civil Rights, which I've been engaged in very actively as a board member and as someone who has worked on Lawyers Committee cases. In 2008, and we had a meeting in early 2009. The Lawyers Committee called me and asked me if I thought Wiley would be willing to get involved in the case, and so that's when we started working on it, and through a lot of due diligence to make sure that what we were hearing was consistent with medical records that we had to accumulate and review, and we had to walk our clients through the exhaustion of remedies process, which is fairly rigorous in the context of federal prison litigation. And we had to try to give the Department of Corrections the opportunity to adopt some self-help measures before we took them to court. And we eventually worked our way through all of that by July of 2012. At which point we filed our class action complaint in the U.S. District Court for the Western District of Virginia in Charlottesville. We survived a motion to dismiss. We survived 2 or 3 different changes in the identity of the private for-profit company that provides the medical care at the facility and the disruptions that each of those changes caused. We finally got to the point where we filed our papers for class certification and got a favorable ruling on that in the summer of 2014. We then had dispositive motions practice. The Department of Corrections tried to get the whole case kicked out on summary judgment. We defeated their motion in its entirety and actually won a couple of issues ourselves on summary judgment so that we wouldn't have to try those issues. And then on the verge of the beginning of trial, early December of 2014, the Department of Corrections had a startling change of heart and indicated that they wanted to settle the case as quickly as possible and adopt the measures that we were advocating for to try to make things better in terms of the medical care at the prison. So we entered into a memorandum of understanding with them right on the eve of trial. We negotiated over the course of about 8.5 months to get to the point where we actually had a settlement agreement with all of the relevant terms and conditions agreed upon. We presented that to the court in September of 2015. We had a fairness hearing at the end of 2015, and in February of 2016, the court entered an order approving the settlement agreement. And that would be a wonderful story if it was all over and done with, but unfortunately, enforcing the settlement agreement has proved to be challenging, so we're still working on that matter.
Well, thank you for sharing. It pops into my head that it's sort of an ongoing saga, but it's
it is
incredible work and really meaningful. Are there examples of other pro bono matters that have been particularly meaningful to you that you might be able to share?
I think it's all been meaningful in a real way. I did work on a death penalty case. I took a case in 1991 from the ABA Post-Conviction Death Penalty Project, which at that time was being run by Esther Lardent, someone near and dear to your heart.
Yeah, it all comes full circle, right?
And I represented my client in that matter for 18 years. We went through federal habeas corpus proceedings subsequent to the denial of cert against us by the Supreme Court in the habeas matter. We initiated collateral proceedings, relatively novel at that point in time, in conjunction with the Innocence Project, the original Innocence Project in New York, Barry Scheck's organization, seeking to compel the state to produce for purposes of DNA testing certain critical elements of the physical evidence from our client's murder trial, which had taken place in 1983. We fought about the DNA evidence for a number of years. We finally got to the point where the court allowed us to take some discovery with regard to the chain of custody and where the evidence might be and whether it should be compelled. And unfortunately, at that point in time, we finally sort of came to the end of the road because the state was unable to come up with the evidence. They claim not to have known what happened to it. Their forensic lab had gone through several office moves during the course of the number of years that the case was pending. They speculated that it had gotten lost in transition at one or the other of those moves. And unfortunately, under the Supreme Court precedent in Youngblood versus Arizona, in the absence of being able to show that evidence was intentionally destroyed, you don't have a due process cause of action based on the absence of the evidence. And we were unable to show that anyone had consciously destroyed the evidence that we were after, so there was nothing for us to test, and in the absence of anything for us to test, the court concluded that the execution could be carried out, and my client was executed in February of 2009. It was probably the most emotional commitment I've ever made to anything that I've ever done as a lawyer, including being present at the execution, and because I told my client that I would be there. And it was, so that was probably the most significant thing I've ever done.
Yeah, thank you for sharing it. I don't have a smooth transition to go from that to sort of anything else. That's just,
yeah, I don't think there is one.
No, it's just incredible. And it's the type of thing that stays with us, right, forever. You talk about how do you process it. You process it sort of day by day for the rest of your life. I mean, it really it's incredible stuff. I will say we're speaking. It's July. It's summer associate season. What
Right.
advice do you have for law students and lawyers who are just starting their careers?
I think get started early. To the extent that you feel like you either went to law school because you believed that you would, do good in the world, or because in large law firms, pro bono opportunities tend to provide the best professional development training opportunities for young lawyers that otherwise, may be at the low end of the totem pole on big cases where all they get to do is grunt work, or whatever it is, or because, of a personal connection in your individual life that makes you want to have the opportunity to do something positive with regard to an issue that's affected a family member or whatever. Whatever it is, and it took me a while, I think, to come to this realization myself. As I mentioned, it really wasn't until well into my time as an associate where I felt like I was ready to, handle the responsibility of being the lead on a matter, a pro bono matter. People, the need is staggering, and people need help. And your legal education and your law degree is basically a license that other people don't have to provide a certain kind of assistance to people in need that is, invaluable. And so even if you're not so sure that you're ready, get involved early, because that person, whoever it is going to be better off with you sort of stumbling around, learning as you go along, than they would be without you. And so I think that's, that's the lesson, if there's one that I could impart. If you have the commitment for whatever reason, don't wait until you're a fourth or fifth year associate to dive right in. And I think over time we have here at Wiley, in appreciation of sort of that sentiment, made work on at least one pro bono matter sort of a compulsory element of our summer program, so that when folks come back, if they do, as full-time associates, a year out from the end of their summer here, they have already, had the experience. They know what it's like to be engaged. They understand the benefits that they might derive. They understand the benefits that the clients clearly derive from their involvement. And they're anxious to get back into it, within like a week or two of when a new associate class starts in the fall. I begin to get calls from people about what's going on, how can I get involved, et cetera. And that's a very positive thing.
That's great. Well, we are fired up. I think the Notre Dame coaching staff could call on you to motivate the troops, Ted, let's wind down with this. Who is your pro bono role model? Feel free to pick more than one, and why.
I think for me, people like Tom Williamson, who was the partner at Covington, who passed away earlier this year. People like Ben Wilson, who's the managing partner at Beveridge and Diamond. People like the late John Payton. Those were my role models. I didn't necessarily think that I was going to be a private sector, big firm lawyer long-term when I started. And seeing the incredible competence and capability and ease almost. I know it wasn't easy because I've learned over time doing it myself that it's not easy, but the seeming grace and ease with which those guys and people like them, particularly, for myself as African-American lawyers in big firms, the way that they manage to sort of balance their commitment to the community and the demands of their practice and flourish in both venues was really very powerful to me, very important to me, and I certainly appreciate having had the opportunity to see people like that function in the role that I was trying to sort of cultivate for myself.
What a wonderful note to end on. Ted, thank you so much for talking with me today. It's been a pleasure and incredibly inspiring.
Thank you, Rena. I appreciate it.
Thank you so much to Ted for making the time to be with us. New and archived episodes of the podcast can be found on Apple Podcasts and YouTube. Be sure to subscribe if you haven't already. And if you're listening on iTunes, or what's now known as Apple Podcasts, please take a moment to leave a review. It's quick and easy to do. You could just leave a rating or add some comments, whatever you'd like. We'd appreciate the feedback, and it would help make it easier for other listeners to find the show and expand the conversation about pro bono and access to justice. Hey listeners, we'd love to hear from you. Send your comments, feedback, and suggestions to probono@probonoinst.org. For all of us here, thanks for listening, and we'll see you next week.